right, you ready? All righty. The Subcommittee on the Interior will come to order. Without objection, the Chair is authorized to declare a recess at any time. Thank you all for being here today for this meeting of the Interior Subcommittee of the Oversight and Government Reform Committee. Thank you, Mr. Chairman of the full committee. Chairman Chaffetz has joined us today, as well as our ranking member, Ms. Lawrence, and we will have others join us. We're here this afternoon to discuss barriers to the recovery of endangered species and hopefully how we can break those barriers down. The Endangered Species Act was signed into law by President Nixon in 1973. Its primary goal was to prevent the extinction of imperiled plant and animal life and to recover those populations by removing or lessening threats to their survival. Species are considered for listing primarily through a petition process. Anyone can file a petition, and the Fish and Wildlife Service has 90 days to respond. If the service determines there's merit to the petition, they have 1 year to either list the species, determine it is not warranted to list the species, or that listing is but precluded by other priorities. According to the Fish and Wildlife Service website, there were 2,258 plant and animal species on the threatened or endangered species lists. According to the service's delisting report, 63 species have been removed from the endangered species list. 34 have been recovered, 10 have gone extinct, and 19 species were listed in error. That's not a great track record. Some will argue that simply spending more money will fix the problem. But even former Clinton and Obama administration Deputy Interior Secretary David Hayes stated to the Environmental Law and Policy Annual Review in 2013 that this has been fish-in-the-barrel litigation for folks who, because there's a deadline, and we miss these deadlines, and so we've been spending a huge amount of, in my mind, relatively unproductive time fending off lawsuits in this arena. End quote. There seems to be bipartisan consensus that changes need to be made to improve the law, which has been under siege by litigation. ESA decisions are increasingly driven by litigation, the threat of litigation, closed-door settlements, and in some cases, the whims of federal judges. Serial litigants flood the agency with petitions, and when the Fish and Wildlife Service predictably fails to meet rigid statutory timelines, they sue. The service eventually settles in court to set priorities behind closed doors with the serial litigants, and the process repeats. Such litigation does little more than benefit lawyers and diverts time and resources away from species conservation. What is needed is boots on the ground instead of briefcases in the courtroom. Flexibility for the service needs to be accompanied by an increased emphasis on species recovery planning, as well as increased utilization of state and local stakeholders for data collection, habitat conservation, and the grunt work of protecting and ultimately recovering a species. The Gunnison sage grouse, the lesser prairie chicken, dune sagebrush lizard show that states and locals have the expertise, resources, and will to lead on species conservation. Today, I hope to hear from our panel on how to better harness these voluntary conservation initiatives that I believe are critical to actually recovering species, and when we can, keep them off the list in the first place. Our witnesses today will talk about their efforts on candidate conservation agreements, on habitat conservation plans, and on efforts to overcome serial litigation. I welcome your input and hope we can have a productive discussion on how to improve the success rate of species recovery and delisting. Thank you. I now recognize Ms. Lawrence, the ranking member of the Subcommittee on the Interior, for her opening statement.
Thank you, Madam Chair. Thank you for holding this important hearing. American species face challenges on many fronts, including real estate development, energy exploration, and global climate change. In my own state of Michigan, there are roughly 25 federally recognized endangered or threatened species, including the Kinnear blue butterfly and the eastern Prairie fringe orchid, both found in or around Detroit. But I'm optimistic that all of these species can be saved. That's because the nation's principal statute, the Endangered Species Act, has a remarkable track record. 99% of the species that have qualified for its protections are still with us today. The Endangered Species Act of 1973 was a bipartisan legislation passed by Congress and signed into law by President Nixon. The Endangered Species Act's purpose is to conserve species identified as endangered or threatened with extinction and conserving the ecosystems on which they depend. Some want to roll back those protections. They point to a low rate of delistings to indicate the failure of this important legislation. They complain that there is too much litigation. They support bills to sidestep the scientifically informed regulatory process. I think it is an unfortunate point of view and ignores the reality. The reason species are listed for protection under the Endangered Species Act is the inability or unwillingness of state wildlife agencies to protect them from extinction. I'm not saying that there cannot be differences of opinion about the status of given species. Fortunately, the federal law requires that these opinions be informed by science and not guided by political rhetoric or self-interest. Under this administration, the Fish and Wildlife Service has delisted 18 species, 16 due to recovery, which is success, more than any other administration since this act was enacted in 1973. So in conclusion, we should be celebrating the Endangered Species Act, not detracting from it, and that means funding the Fish and Wildlife Service so it can use all the tools that Congress gave it, including voluntary candidate conservation agreement with assurances and habitat conservation plans, in addition to formal listings. Inadequate funding has meant long line and excessive delays in the agency's consideration of these various measures at protecting the endangered or threatened species. That is a shame, but one that was created by Congress. I thank our witness for appearing here today, and I look forward to your testimony, and really want you to know that I am extremely committed to ensuring that we in America continue the leadership in protecting all endangered or threatened species. Thank you so much.
Thank you. I will hold the record open for 5 legislative days for any member who would like to submit a written statement. The chair notes the presence of our colleague, Congressman Ryan Zinke of Montana. We're delighted you're here today. Appreciate your interest in the topic and welcome your participation in this hearing. I ask unanimous consent that Congressman Zinke be allowed to fully participate in today's hearing. Without objection, so ordered. We will now recognize our panel of witnesses. I'm pleased to welcome Mr. Lowell Bayer, attorney at law and environmental historian. Mr. Rob Thornton, partner at Nossaman LLP. Mr. Joel Bausman, chairman of the Board of County Commissioners of Sublette County, Wyoming. Mr. Robert Glicksman, the J.B. and Maurice C. Shapiro, professor of environmental law at the George Washington University Law School, and Ms. Karen Bud Fallon, senior partner at the Bud Fallon Law Offices. Welcome to you all. Pursuant to committee rules, witnesses will be sworn in before they testify. Please rise and raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. Let the record reflect that the witness is answered in the affirmative. In order to allow time for discussion, please limit your oral testimony to 5 minutes, and thank you all for being willing to come to this hearing early. This way we have a chance to hear from our witnesses and hopefully answer some questions before the panel gets called to votes. In order to allow time, we'll have your entire written statement made part of the record. So if you choose to cut it short, don't be worried that your remarks will not be taken into the record. Mr. Baer, you are recognized for 5 minutes, and welcome.
Thank you, Madam Chairman. Members of the committee, a primary incentive to litigation that's a barrier to delisting is money. Money, money, money. It's that simple. It's the reimbursement of legal fees. Now, I first became interested in this topic after reading some of my co-witness Karen Bud Fallon's writings on the 1980 Equal Access to Justice Act, which in turn led me to a 5-year research project that resulted in my new book just published, which is here on the dais or on the table, entitled Inside the Equal Access to Justice Act, an Environmental Litigation and Crippling Battle over America's Lands, Endangered Species, and Critical Habitats. And I couldn't understand from my research, which is what got me into it, how a handful of small litigation groups masquerading under the banner of environmental stewards could wage serial litigation wars on our federal land management agencies. So I did what a good forensic investigator does. I followed the money trail. And it led to my finding that the citizen suit provisions in the Endangered Species Act and the 1980 Equal Access to Justice Act pay a bevy of both in-house and outside attorneys on retainer who parade under the title of, quote, pro bono counsel, but are in fact paid handsomely for their work by the U.S. Treasury. So the number one incentive to litigation that stymies delisting is money, the reimbursement of legal fees. Let me give you a graphic of the money trail that followed the 2011 multi-district litigation settlement, which expires at the end of the next fiscal year in 2017. Now, this is a graphic that we created. Can we get that up on the screen, or is it on your monitors? There it is. No, that's not it. This is what it's. Oh, there it is. Good, good. All right. Now, if you look across the top, right here, right across the top of this, you'll see a bunch of boxes up there. There are 8 boxes. I'll wait for a moment for you all to get that in front of you. All right, there are a series of boxes across the top. Each of those represents a lawsuit. What happened is the 2 litigants, Wild Earth Guardians and Center for Biological Diversity, in a pincer action, literally surrounded the Fish and Wildlife Service with these lawsuits in different districts throughout the United States. And so in order to get these consolidated and dealt with in one court, so their personnel and their resources weren't stretched, the service consolidated them here in Washington. And the court here then added, over on the left side, here, right where I'm pointing, 3 more cases. So now we have a total of 15 cases in front of the U.S. District Court here in the District of Columbia. And the judge asked the parties to try to settle. They did reach a settlement agreement. It's in September of 2011, which we refer to as the multi-district litigation settlement. Now, you would think, folks, that at that point, the case is over. It's settled, and now the Fish and Wildlife Service has a whole order of a calendar that they set up, 1,030 species were now on their calendar. So between 2011 and 2017, they had a calendar to follow of species that they were supposed to then make a decision on as to whether to list, delist, or not find an appropriate listing. And what happened was they began to work their way down through the 1,030 over the calendar. And as they made decisions, these two litigants continued to then sue them because they didn't like the decision the Fish and Wildlife Service made, whether it was to list or delist. Or not delist, but not list at all. And so what's happened is we had 15 cases consolidated, and if you look at the list on the far left, these are the challenges that they issued after September 11th, each of them a separate lawsuit. And in the middle are other lawsuits that were generated by the settlement agreement. And on the far right, more lawsuits. So what the settlement did is nothing but generate a whole series of new lawsuits. And I scratched my head, and what's driving this? The money trail. That's what the money trail led to. I can see that I'm about out of time, Madam Chairman. This litigation has undermined the work of Dan Ash and the service, who were promoting cooperative conservation projects with the states and with private sector that put money on the ground, boots on the ground money, and not money into lawyers' pockets. And this trail has demonstrated that their hard work to do cooperative conservation work is being undermined by lawsuits. I have more, Madam Chairman.
Thank you, Mr. Bayer. I gave you a few extra seconds
thank
because
you.
it took me a while to find the exhibit and get on track.
Well, thank you for your indulgence.
Yeah, I appreciate your preparing the exhibit.
Should I continue then?
You know, I think that we'll ask you questions. So with that, Mr. Thornton, you are recognized for 5 minutes.
Madam Chair, members of the committee, it's a pleasure to be with you today. I will summarize my testimony. I'm a partner in the Nossaman Law Firm, but I'm testifying as an individual, not on behalf of the firm or its clients, but the firm is an affiliate of the California Association that's affiliated with the National Association of Home Builders. My testimony is based on my 3 decades of experience representing both plaintiffs and defendants in Endangered Species Act matters, and focuses particularly on efforts to delist 2 species, the coastal California gnatcatcher and the Valley elderberry longhorn beetle. I've left with staff some pictures because it's always nice to have pictures to put with descriptions. Our view is that the best available science indicates that neither species should be listed because neither are endangered or threatened, and that the service's consideration of the delisting petitions for these 2 species exemplifies the barriers to delisting, even in circumstances where published in peer-reviewed studies and the service's own status review document the original grounds for listing are wrong. I'll focus on the California gnatcatcher. The gnatcatcher is a species, is a common Mexican bird that's found from Southern California, the tip of Baja. You have a range map there showing the range of the gnatcatcher. There are likely several million gnatcatchers in Mexico. The coastal California gnatcatcher, which is the listed subspecies, is found from Southern California to El Rosario in Baja, Mexico. The subspecies designation is important because the petitioner for the listing, Dr. Jonathan Atwood, testified that, quote, no credible scientist would claim or has claimed that California gnatcatchers as a species are endangered or threatened throughout their range. Using 19th century ornithology, the service listed the coastal gnatcatcher as a distinct subspecies in 1993 based on 2 crude measurements of 2 physical features, the brightness of breast feathers and the purity of back feathers, and that they took the position that the differences in these 2 physical features constituted sufficient genetic distinctiveness to justify the listing of the subspecies. During the extensive delisting or listing debate in the 90s, several nationally recognized scientists testified that the data did not support this conclusion, in part because the measurements of the two physical characteristics were based on measurements of museum specimens, some of which had been sitting in museum desk drawers for 100 years. After a federal court initially invalidated the listing, the service relisted the species relying on what they call morphological data. Now, over the next 7 years, a group of nationally recognized scientists conducted genetic analysis of mitochondrial DNA. Mitochondrial DNA is the DNA that we all inherit from our mothers, and this was, at the time, the state-of-the-art method for analyzing genetic differences among animals. Those studies published in a peer-reviewed study published in the very well-known journal Conservation Biology concluded that there is no material genetic differences between any gnatcatchers throughout the entire range, its range from Southern California to the tip of Baja. In 2010, a group of landowners petitioned the Fish and Wildlife Service to delist the gnatcatcher based on that study. That delisting petition was denied. Essentially, the service said that the mitochondrial DNA evidence was not sufficient and said that what was required was a nuclear DNA study. The scientists went back to the lab and in 2013 published another study, this time based on nuclear DNA, reconfirming the results of the prior study that there is no significant genetic differences and that the listing of the subspecies is not warranted. On behalf of several organizations, we filed a petition to delist. The final decision on that delisting petition is still pending, but we're concerned for, among other reasons, we filed a Freedom of Information Act to obtain documents regarding the service's review of the delisting petition, and the service is refusing to provide us any substantive documents regarding their external review of the delisting petition. That is their engagement of an outside contractor to review the delisting petition, and they're even refusing to disclose the identity of the individuals conducting the review, which we believe is a violation of the Endangered Species Act. Thank you, Madam Chair and members of the committee.
I thank the witness. Mr. Bousman, you are recognized for 5 minutes.
Thank you, Chairman Lummis, Ranking Member Lawrence, and members of the Interior Subcommittee. My name is Joel Bousman. I am a rancher and county commissioner in Sublette County, Wyoming, currently serving as second vice president for the Western Interstate region of the National Association of Counties. Today, I am speaking to you as a Sublette County, Wyoming commissioner. When a species is put on the Endangered Species Act list, it's a bit like checking in to Hotel California. You need to look no further than the Great Lakes wolf to find that barriers to delisting species are a nationwide problem with implementation of the ESA. At the county level, we do not deny the value of protecting truly endangered species, but it is troubling to us that the goal of the ESA appears to be permanent and perpetual listings rather than species recovery. It is also troubling that the ESA itself has created a system that incentivizes closed-door litigation over cooperation with local governments. Often when we think about the ESA, we tend to think about the federal government's relationship to the states. All across the West, state game and fish agencies are the local experts that should be trusted with managing our wildlife appropriately. However, it is important to understand that the Fish and Wildlife Service also has an obligation to consult with and receive input from counties affected by petition listings and regulations written as a result of those listings. Section 1533 of the ESA twice lists counties as necessary partners in the process. While the language is clear, its overly vague instructions let the Fish and Wildlife Service off the hook on any meaningful coordination with counties. This is a part of the ESA that is crying out for congressional attention. The National Association of Counties has adopted a permanent policy that seeks to improve the ESA by mandating that, and I quote, federal agencies treat state and county governments as cooperating agencies with full rights of coordination, consultation, and consistency to decide jointly with the appropriate federal agencies when and how to list species, designate habitat, and manage for species recovery and delisting," unquote. What is it that counties have to offer that others do not? First and foremost, what we have to offer is a broad view on both the need for ESA listing and the effects on our counties resulting from those listings. By the very nature of the charge of the office, a county commissioner must take into account the health and welfare of their entire county, its people, land, water, and wildlife. We have found in Wyoming that the most successful efforts of federal land managers on any topic have been ones that were developed collaboratively with local governments. The best decisions are made by people working together on the ground at the local level. As it is currently written, the ESA does not promote and certainly does not require collaboration with local governments. This is a mistake. The Fish and Wildlife Service would benefit from a coordinated effort with local governments, not required at this time. Such a change would create more meaningful conservation, which should be our collective goal. It would also help to inoculate the Fish and Wildlife Service from the kinds of groups who appear to be more interested in money to be made from litigation than boots-on-the-ground species conservation. There may have been a time in America's past when inflexible laws were necessary to overcome cultural apathy towards conservation. But as has been so eloquently explained many times by this subcommittee's chairman, America's signature conservation laws have not kept pace with our cultural conservation ethic. Allowing for greater local input, understanding the custom and culture of the local community, and an honest assessment of socioeconomic impacts is not a threat to species viability. Rather, it would be a help in creating regulations when they are necessary that can be embraced at the local level. The lack of intentional coordination with local governments is a barrier to delisting and would be easy to remedy in looking to improve the ESA. Thank you, and I look forward to your questions.
I thank the witness, and Mr. Glicksman, you are recognized for 5 minutes.
Madam Chair, Ranking Member Lawrence, and subcommittee members. My name is Robert Glicksman. I'm the J.B. and Maurice C. Shapiro Professor of Environmental Law at the George Washington University Law School, although I speak today solely in my personal capacity. I've taught and written about environmental and natural resources law for 35 years, and am a co-author of the leading treatise on public natural resources law. I appreciate the opportunity to testify today on the Endangered Species Act. I'll make several points. First, as the Government Accountability Office has recognized, the success of the Endangered Species Act cannot be measured in delisting alone. By one account, more than 250 species would have disappeared in the U.S. during the ESA's first 30 years if they hadn't been listed. As of 2014, about 36 species had been downlisted from endangered to threatened, and 3 times as many had been delisted as declared extinct since the ESA's adoption. The condition of other species has improved, though not yet enough to justify delisting. One study found that 90% of species are recovering at the rate specified by their federal recovery plans. Species recovery can be slow for reasons having nothing to do with the ESA's utility. Species are not listed until they are already in very bad shape. It's not surprising that it may take years or even decades to bring them back from the brink. Some species are slow to respond to recovery efforts. They may reproduce slowly, face ongoing unbated threats, or require habitat that government hasn't yet been able to secure. Recovery efforts may hinge on unavailable information about threats facing species or how best to mitigate them. Both the GAO and Fish and Wildlife Service biologists have found that ESA recovery plans play an important role in identifying actions that scientists deem most important to recovery. Second, resource constraints have prevented the ESA from being even more successful in staving off species decline and promoting recovery. Congress has long funded the ESA at levels inadequate to enable the Fish and Wildlife Service to carry out its responsibilities. Researchers have estimated that over the past 15 years, spending to protect listed species has covered only about a third of the recovery needs. A study published last month found a strong correlation between recovery funding and trends in population levels. It found that only about 12% of listed species are receiving funding at levels prescribed by the recovery plans, but that recovery goals are 2.5 times more likely to be met for those species than for those inadequately funded. Congress should redress the chronic underfunding of the ESA, as Fish and Wildlife Service Director Dan Ash has called on it to do. He has also recommended increasing financial incentives for species conservation by non-federal actors. But instead of continuing or increasing programs that assist states and private parties in conserving listed species, Congress is cutting or ending these effective programs. They include programs to fund acquisition of land needed to support listed species and to help farmers protect biodiversity on their land. Third, some trace difficulties in the ESA's implementation to efforts by citizen groups to compel species listing through petitions filed with the Fish and Wildlife Service or lawsuits in federal court. Congress has recognized the vital role that citizens can play in helping to implement laws that protect civil rights, voting rights, consumer protection, and the environment. Citizen-initiated lawsuits help ensure that individuals and groups from across the political spectrum with a wide range of interests can call on the federal courts to ensure accountability of agencies and their compliance with conditions Congress imposed on them. Those contending the Fish and Wildlife Service has been both too aggressive and not aggressive enough in protecting species. Those who want both less and more government intervention have consistently taken advantage of their access to the courts. Senator Edmund Muskie recognized decades ago that the concept of compelling agencies to carry out their duties is integral to democratic society. Administrative failure should not frustrate public policy, and citizens should have the right to seek enforcement. Congress authorized suits against the Fish and Wildlife Service to enforce listing-related duties, to increase opportunities for citizen participation in the policymaking process, and to address concerns that political pressure might discourage listing of deserving species. According to a prominent ESA expert, citizen suits have played an important role in almost every aspect of the ESA implementation. Greater funding would be one way to redress, or at least address, the backlog that the Fish and Wildlife Service is currently experiencing in responding to petitions both to list and delist species. I look forward to your questions.
I thank the witness, and Ms. Bud Fallon, you are recognized for 5 minutes.
Thank you. Chairman Loomis, and Minority Leader Lawrence, honorable members of the committee, my name is Karen Bud Fallon. I am a fifth-generation rancher who is working to ensure that that ranch we have in Big Piney, Wyoming is secured for a sixth generation. I'm also an attorney who has worked to protect our ranching heritage, our way of life, from the federal government overreach, including that of the Endangered Species Act. Chairman Loomis went through some of the numbers today, and I think those numbers are important to understand. There are 2,258 plant and animal species listed as threatened or endangered, 1,592 of which are located in the U.S. Part of listing a species is also critical habitat designation, yet only 791 of these species have critical habitat designated. And even with that backlog, the Fish and Wildlife Service data indicate that there's another 1,508 species that are pending for review as either listed, pending as listing as threatened or endangered. Today's hearing is about delisting, so we should consider the number of species that have been delisted and recovered. According to the Fish and Wildlife Service, that total number is 63. Analyzing that list, the numbers of species that have been removed because of a listing error is 19. The number that were recovered is 34. The number that has gone extinct is 10. And while the Obama administration is correct that it has, quote, recovered more species than ever, part of that recovery is based on development of recovery plans. The problem is that the number of recovery plans has significantly been decreasing. For example, if you look between 1990 and 1999, 843 species were included in a recovery plan. Between 2000 and 2009, the number of species included in a recovery plan dropped to 235. And from 2010 to today, only 177 species are included in a recovery plan. I would argue that there are three problems with the delisting of species, and the number one problem is priority. It does appear to me that when you look at the decrease in species included in a recovery plan versus the increased number of species listing, that the priority is in listing, not in setting recovery plans to get species off the list. When you look at the congressional record for the Endangered Species Act, it talked about recovery and getting species off the list. There is nothing in the congressional record that indicated that species were supposed to get put on a list and parked there forever. The second problem that I see happens is that so often recovery goals are simply not set. And that's a hard issue for me to understand. If the Fish and Wildlife Service has enough information to determine that the number of species is getting close to extinct, certainly at the same time it can come up with the converse to determine how many species we need so that the species is protected. And once you set forth that number and those goals, then landowners, then states, then the federal government knows what to manage for. But so often these recovery numbers and the numbers of what to manage for are never included so that the public doesn't know what the end goal is. And I think that that is a barrier to getting species off the list. If we know where we're going, we can figure out how to get there. The third problem I see is such difficulty in developing candidate conservation agreements with assurances or candidate conservation agreements. Currently, only 70 CCAAs or CCAs are in existence. I've worked on numerous of those. One of the big differences we have in those is looking at different regions of the Fish and Wildlife Service have completely different policies on what is an adequate CCA or CCAA. Look at the one for the greater sage grouse, which did keep the sage grouse from being listed, but the policies in the different regions of the Fish and Wildlife Service on how to develop those candidate conservation agreements were completely all over the board. A lot of people yesterday in the hearing touted the CCAA for this greater sage grouse in Oregon and Washington because they had a saying there, what is good for the bird is good for a herd. The problem is when you talk to those Fish and Wildlife Service people, they will tell you that they went out on a limb because the candidate conservation agreement looked at the entire ecosystem, not just at the species. And when you look at the entire ecosystem, they were able to develop a CCAA that dealt with all of the issues and protected landowners as well as protecting a bird. You can't do that if you're singly focusing on the species. The second issue that we come up with in terms of CCAAs and CCAs is the difficulty in litigation. If you don't have enough time in the litigation, you can't allow the policy to work. With that, I would stand for questions. Thank you.
Thank you, panel. And I'm pleased to report that it appears that we'll be able to complete our hearing without being interrupted by votes. So the strategy of moving this hearing an hour earlier has been successful, allowing this panel an opportunity to ask questions of you, which we will begin now. So thank you for your testimony. And the chair will yield herself 5 minutes to begin questioning. Ms. Budd Fallon, how did we get to the point where the Fish and Wildlife Service spends most of its time in court rather than helping boots on the ground recovery of species?
Madam Chairman, I think the answer to that is when you look at the Endangered Species Act, the only timeframes that are included are listing timeframes. You petition a species for listing, Fish and Wildlife Service is mandated to respond in 90 days. They miss that 90-day deadline, litigation can occur. If they meet the 90-day deadline, then they have a 12-month finding that the Fish and Wildlife Service is mandated on issuing. They miss that deadline, litigation can occur. There are 8 different places in the listing process that litigation can occur. And litigation occurs in all 8 of those areas. But if you look on the converse side, there are no mandatory timeframes, so you can't mandate that the Fish and Wildlife Service create a recovery plan or delist a species because there's no mandatory timeframes for that. And so I think the Act was set up to enforce the listing but not give us the chance in court to enforce delisting or recovery plans because the Fish and Wildlife Service always prioritizes something else first.
Thank you. A question for Mr. Bayer. Now, in terms of the use of litigation, not just to force listings, but to block delistings, do you think in Congress in 1973 they envisioned or intended litigation to play this role under the ESA?
No. The answer is no. My next book is that we're well into the research on is on the Endangered Species Act. And its history and its application and the flashpoints that we're experiencing with it. In that research, I've been going around the country interviewing the people that wrote that act starting in 72, well, going back to 66, when the Organic Act. And I've been talking with the folks that actually wrote this act back in 72, 73. John Dingell was the floor manager. He wrote the preface for this book. And I've asked John and I've asked many others that were really involved with this back then about that very question. And they just assumed delisting would happen. Because I said, why in the 73 Act is the word delisting only appears once? The word is only in that act one time. And I said, what were you folks thinking back then about this? And they said, well, you know, our focus was protecting the eagle, the condor, the iconic species in America. That's what our focus was. So the whole ideology of the act, when you read it through, the systemic focus of the act is on listing. And they just assumed delisting would occur. And they have all said universally that if they could go back today, they would have put appropriate criteria in for delisting.
Thank you. Ms. Bud Fallon, you began to describe the process to reach a candidate conservation agreement. What are some of the ways that the process could be improved?
I think the first way that the process could be improved is to allow the process to look at the ecosystem of the species rather than the species itself. I realize that the ESA says species and the ecosystems upon which they defend, but the litigation occurs over species listing, and so that is the focus. I think to broaden that to look at landscapes, at ecosystems would help. The second thing I think we have to look at is really focusing on making on-the-ground improvements to the land. I think that so often these end up in big paper exercises with no incentives for landowners to participate that it's very difficult to convince them to do it. For example, if you look at the Lesser Prairie Chicken range-wide plan, that was actually a really good combination of allowing oil and gas development to put up funding so that private landowners could then protect species. It is a great balance. The problem with the Lesser Prairie Chicken listing was that the time ran out because of a litigation settlement agreement. So the Fish and Wildlife Service said, even though we agree with this range-wide plan, even though we think this is a wonderful thing, we are going to not consider it and list the species anyway, so you had litigation occur. The time just ran out.
Thank you. My time has expired, and I will now recognize the ranking member, Ms. Lawrence, for 5 minutes.
I really appreciate the witnesses and the different perspectives that you're bringing today. According to the Fish and Wildlife Service and the National Marine Fisheries Service, state agencies are the primary protectors of endangered species, and I quote, "States possess primary authority and responsibility for the protection and management of fish, wildlife, plants, and their habitats. Too often, states are either unwilling or unable to exercise that authority effectively. That is when the federal government must step in. The reason species are listed for protection under the Endangered Species Act is a failure of states to protect species from extinction." So, Mr. Glicksman, will you comment, do states have the ability to be proactive and to implement their own conservation efforts before species need to be considered for listing?
They do. Congress was careful in enacting the Endangered Species Act to preserve traditional state prerogatives in many areas in managing wildlife. The Endangered Species Act vests the Fish and Wildlife Service and the National Marine Fisheries Service with authority as kind of a backstop in the event that the states don't take adequate measures to protect wildlife species within their borders. The statute preempts state authority only if it is in conflict with measures adopted by the federal government under the Endangered Species Act. So the states really have the first opportunity to protect endangered species, and the Fish and Wildlife Service will step in only in emergencies, that is, when the species are already on the brink of extinction.
Have there been cases in which the state did fail to implement and follow through on an adequate plan to ensure the recovery?
There are certainly examples of that, and one that comes to mind is with respect to the gray wolf in Wyoming. There you had a species that was in trouble in at least 3 states, Montana, Idaho, and Wyoming. Montana and Idaho came up with plans that adequately addressed the problems that the species was encountering. Wyoming did not initially. A court remanded the Wyoming plan back to the state to fix it. The Fish and Wildlife Service ultimately approved Wyoming's plan, but on judicial review, a court concluded that the plan was again inadequate, primarily because it did not include binding commitments to ensure that wolf populations remained above minimal levels specified in the recovery plan that the state had adopted.
There's been similar examples where delisting of wolves did not occur because judges noted a lack of protections as a reason to not delist the wolves. So we talked about litigation, but there also has been that role that the state has to play, and these states have included North and South Dakota, Iowa, and Indiana, to name a few. Do you believe, Mr. Glicksman, that the court was justified in finding that the unregulated killing of wolves might represent a real threat to their survival?
One of the requirements that the agency has to take into account, both in listing and delisting decisions, is the adequacy of existing regulatory mechanisms to protect the species. I think the court in the gray wolf case concluded that, among other things, the state's designation of 90% of the state's territory as a predator area for the wolf, and its designation of only about 10% of the wolf habitat as a trophy game area in which the taking of wolves would be regulated and restricted by the state was inadequate. The court felt that giving that degree of authority to hunters to kill wolves would not be sufficient to meet the target level specified in the plan of 10 breeding populations and 100 animals.
Thank you. Madam Chair, I yield back my time.
gentlelady, and recognize the gentleman from Alabama, Mr. Palmer, for 5 minutes.
Thank you, Madam Chairman. Ms. Bud Fallon, recently the administration has come out with new regulations and policies for designated critical habitats for endangered species. Could you briefly describe for us some of the major changes these regulations create? And I would like briefly, if possible.
I believe that the new Obama changes to the critical habitat rules between 2012 and 2016 completely turn over the designation of critical habitat to anything within the whim of the Fish and Wildlife Service. The new rules allow the designation of potential critical habitat, even if that habitat does not have the primary features of the habitat. So it basically means that any circle can be drawn on a map and anything is now critical habitat, which then makes it significantly harder for private property owners and federal grazing permittees.
What kind of effects will these regulations have on federal, state, and private landowners?
Mr. Palmer, I think that these are going to have a significant impact. The problem is that the adverse modification rules were also changed, which means that now a private landowner or a state cannot adversely modify critical habitat, which means it would slow its progress toward becoming critical habitat at some time in the future. And we don't know when that future is. It could be you can't now, cut your hay meadow, or you can't now graze your field because in the next 200 years it may contain the features necessary for some threatened or endangered species. That's where the rub comes.
And I would also add that they really don't take into account the economic cost and the burden that's imposed by these critical habitat designations.
No, that was eliminated by the 2013 rule, which eliminates the consideration of economic analysis.
And it doesn't take into account the burden on the private landowners.
No, sir.
Let me transition here a little bit. One of my concerns with what's going on not only with Fish and Wildlife and National and the Marine Service, Marine Fisheries Service, includes the EPA, and that is this whole issue of sue and settle that you brought up, Mr. Glickman. Do you not see that as very problematic in terms of how it undermines the state's roles, as mentioned by Ms. Lawrence?
No, I don't see that as problematic. First of all, the states can take measures to prevent species from getting to the point that they are endangered or threatened, and the statute wouldn't be triggered in the first place.
Well, now, let me cut you off there, because I don't think it's about how the state's taken the action in as timely a manner as some people want. It's more a matter of how the statutes are implemented, and particularly this prairie chicken, for instance, is a sue and settle issue. It's a consent decree. And
well, courts have to approve consent decrees, and
yeah,
so the court won't approve a decree that it regards as unfair or inappropriate.
That hasn't been the case. We know that there's court shopping, judge shopping. There's collaboration between these independent outside groups, so-called independent outside groups, and federal agencies to really cook up a agreement on this. So they file the suit, and we don't fight it in court. Or if we fought it in court, I think the outcomes might be different. Have you participated in any of the sue and settle lawsuits?
I have not, no. But I would point out that sue and settle techniques have been engaged in by litigants from a variety of interests. So, for example, there's been litigation in Utah over the scope of RS 2477 rights. Litigation was brought against the federal government and settled.
My point about this is that it is, I think, not only a violation of the intent of the Clean Air Act, the Clean Water Act, the Endangered Species Act. It violates the matching principle that states had. I mean, there's a great piece on this in the Harvard Journal of Law and Public Policy, and the Harvard Journal of Law and Public Policy article basically deals with the EPA, but I think the same principle applies, what's going on with sue and settle is a violation of state rights, and I think private property rights as well. And it's using the courts in a very manipulative and I think disingenuous way to impose these regulations on the states and on private landowners. Madam Chairman, yield.
I thank the gentleman, and I recognize the gentlewoman from Virgin Islands, Ms. Plesquette.
Hi, thank you.
Did
Thank you very much.
Did I pronounce that right?
Yes, you did. Thank you.
Thank you.
Good morning or good afternoon to you all. Thank you so much for your time. Mr. Thornton, you talked about litigation that you've been involved in and the scientific data indicating the issues involving delisting. That's particularly interesting to me, living in the Virgin Islands, the impediments to delisting that you've talked about. Can you explain some of your thoughts on why this occurs, why it's so difficult to delist species?
I think, Congresswoman, I think the fundamental reason is that once a species is on the list, the inertia takes over within the regulatory agency, very difficult to have them reverse that decision. Frankly, the Endangered Species Act provides a lot of regulatory authority and power to the Fish and Wildlife Service, so I think the natural kind of human inclination of a regulator is to want to retain that authority. And once a species is listed, it develops a constituency, usually, that becomes strong advocates to retain that species on the list, even when the science emerges, as it did in the case I mentioned, where we went from, frankly, 19th century ornithology to very sophisticated genetic testing.
You know, this is one time where, with some of my colleagues on the other side, I tend to agree. And I agree wholeheartedly with you as to the advocacy groups that come around and are formed when species come on the list. I live in the U.S. Virgin Islands, and we have enormous impediments that are put on us with our economic development, the growth of the territories, because of the endangered species listing. And because once species are put on the list, there's almost nothing we can do to adequately satisfy the needs of the, you know, you talked about the U.S. Fish and Wildlife, the National Marine Fisheries Association, NOAA, others, that keep us from being able to grow our economy. I'm often, I think, unfairly labeled by many in my community as being against our natural resources, which I think is and not an environmentalist, which I think is an unfair label that has been put on me. I'm worried, quite frankly, about the extinction of the people of the Virgin Islands that are occurring because of the endangered species listing. In August of 2014, 19 new corals were listed by the Endangered Species Act, requiring specific ways in which we could operate around these corals that were put on this list. It cost us now 30% more to develop in the territory because of this listing. And that really necessitates, in some instances, developers leaving the area entirely. We've had projects, Williams and Punch, creating dolphins within our coral world. Thatch Key, lots of development can no longer move forward because it takes 2 years to get a biological opinion passed by, and I see you're shaking your head, Ms. Falan, where it takes so long to come up with a plan that says how we're going to move the coral so that we can have sustainable projects take place. And I'm not just talking about resorts that are created for visitors and people who want to come down and enjoy themselves. We were trying to move from fossil fuel oil to propane to reduce the cost of energy in an already exorbitant economy. And it took almost 2 years to get the permitting requirement because in the time period that we put the permit, this listing came up in August 14 that has absolutely crippled us. I can't imagine what occurs in American Samoa and in Northern Marianas and Guam, where their way of life is being absolutely shut down because of this listing that's put on here, and the fishermen are no longer able to fish at all in many areas because of this listing. Once listed, it's almost impossible to go on with the delisting. I know the administration has said that they have about 28% that have come off of the list, but that is entirely not enough. And they do not have aggressive plans on how to move to delisting. Mr. Glicksman, you talk about the states having inadequate measures. In the Virgin Islands, we believe that we've done and have been doing for hundreds of years a great job in preserving our natural resource. We understand that that is the most important resource that we have. And we are now feeling the effects of global warming that we had nothing to do with. And we are being penalized by the federal government by not allowing us to exact plans that we believe balance the needs of our natural resources and the needs of the people to have jobs and food and be able to sustain themselves with this endangered species. Madam Chairwoman, I know that my time has expired. I guess I really didn't have any questions in the 5 minutes that I had, but I thought it was necessary to put on the record the concerns of the people of the Virgin Islands, and I'm sure the concerns of many communities throughout the United States that feel that there needs to be a balance between the endangered species, which we want to keep, as well as the not endangering the lifestyles, the what we believe are natural and fair lifestyles of Americans living in those areas. Thank you.
The gentlewoman yields back, and I think many people share the frustrations and the goals as on a bipartisan basis of saving species, recovering species, and have the ethic to do so. But are frustrated with a process that is actually beginning to interfere with the ability to recover those species in an effective and timely manner. The chair now recognizes the gentleman from Montana, Mr. Zinke, for 5 minutes.
Thank you, Madam Chairman. I appreciate the opportunity to be on your committee. I guess I, listened to it. One is I think we need more scientists and less lawyers in the woods. I think that's an overriding conclusion. And I appreciate, I can't wait for you to read your book, Mr. Bear, and as a native son of Montana, I think you're aware of it. When I looked at this sage grouse, and I consider myself a Teddy Roosevelt Republican, when I looked at the sage grouse, I talked to Director Cornsey, and I asked him, why do you think the numbers of sage grouse are low? And it depends on where in Montana. Now, bear in mind that Montana is the same distance between here and Chicago plus 2 miles. His immediate answer was oil and gas exploration. I found that somewhat ironic because at the time Montana had 1 oil derrick. Today we have none. So I asked him, does the plan take in consideration predators? We have a coyote population. We have more hawks. The eagle population is soaring, no pun intended. The answer was no. What about wildfires? The answer was no. And the core of the issue was, what does a healthy population of sage grouse look like? Because if we're going to target to return to a healthy population, then we should strive to a number. As a former SEAL commander, metrics are important. The answer was, we don't have one. But it is about habitat. And so if you don't know the difference between Butte and Bozeman, then how can you manage a difference that Butte and Bozeman have? So I guess my question would be to Mr. Bozeman, because I look at it, these collaborative efforts are so incredibly important that we can come together on issues because we all value, I believe, endangered species, and we want to make sure we have healthy populations. But certainly local jurisdictions have a place in it. So, Mr. Bozeman, what level of engagement does the Endangered Species Act require between federal officials and local?
Congressman Zinke, thank you for that question. At this time, Section 1533 of the ESA does say that consultation will occur when deciding whether or not a species is threatened or endangered. It also requires Fish and Wildlife Service to give notice of any pending new regulations or designation and invite comment from the counties, but it does not require any defined level of cooperating agency status or collaboration. And I guess as a local government official, we continually work with both land management agencies in Wyoming, the Forest Service and the BLM. They are required through NEPA to designate local and state governments as cooperating agencies, and they're required to coordinate with any local plans they have in place. That's not true with Fish and Wildlife Service, and I think it would be a great benefit if Congress could change the rules a little bit in terms of Fish and Wildlife Service and their endangered threatened species management to require the same level of coordination and collaboration with local and state governments as what they do with the land management agencies. That has proven to work fairly well when it's taken advantage of. And there's ways that that it goes back to the whole idea that the best management decisions are made at the local level by the local people working together with the local federal agency people in the community, and it takes into account the socioeconomic impact on the community, and it allows you to develop a plan for the species or for the habitat that takes into account those concerns, and it turns out to be a win-win for everyone.
Mr. Bauer, in your book, do you estimate how much is spent every year on litigation by both outside sources and the agency?
The low figure is $1 million. The high figure is, as the best I recall, I know Karen Bud Fallon did publish some numbers on that, and I cannot remember off the top of my head, but it was I think over $2 million.
Is that from the agency or outside sources or combined?
It's a combination of the fees that are paid out by the Treasury Department. Even though the law says they're supposed to come out of the agency budget, they don't. The U.S. Treasury, the Department of Justice authorizes checks being written, comes right out of the U.S. Treasury. But on top of that, you've got to then add the cost to the agency of all the personnel. And that's from talking to all of the Fish and Wildlife Service directors over the past years. They estimate it for every dollar of fee that goes out, anywhere from 5 to 7 times that are spent in personnel costs.
Thank you. And thank you, Mr. Chairman. I yield back the rest of my time.
I thank the gentleman, and with the committee's indulgence, we will do one more round of questioning, but 4 minutes only per person, and then I would like to give each member of the panel 1 minute to say anything that they wish they could have said but didn't get to during the course of this hearing. Fair enough? Okay. The chair recognizes herself for 4 minutes. Mr. Bausman, do you think that the conservation ethic of Americans has changed? Do you think that local governments, such as yours, are willing and able to protect species like the grizzly bear, the wolf, sage grouse, black-footed ferret, and other species that are within their counties?
Congresswoman Lummis, definitely the conservation ethic has changed at the local level, and I'm, in my experience in Wyoming, for example, the local people now look to us as their elected officials to take into account those sorts of things, which 20 years ago you would have never seen a county commissioner at a hearing in Washington, D.C. talking about these kinds of issues. The mindset has changed, and we are in a position now, both willing and ready to work with our state game management agencies to point out at the local level what the problems are. An example could be and we have one in our county, mule deer migration, and bottlenecks that have occurred that inhibits the mule deer from migrating from one place to another where they spend the winter, getting back to the summer, and we're ready and engaged in addressing those issues. And if we could somehow redirect a little bit the Fish and Wildlife Service to become more of a resource for state and local governments to say, how can we help you meet the goals, the conservation goals of a species, we could be much more effective on the ground.
I commend to the panel's attention a drive between Pinedale, Wyoming and Jackson, Wyoming, where there have been overpasses created over a road for antelope and underpasses for elk and deer because the species choose different means of access across the highways. The antelope won't go under an underpass, whereas elk and deer will. And so 2 massive overpasses were built specifically for antelope to cross that road and thereby saving tremendous wildlife deaths on the highway. So I commend Mr. Bousman, your county, and your particular involvement in these issues. Ms. Bud Fallon, a comment was made about Wyoming's wolf recovery plan and its adequacy. Would you care to comment on the wolf case?
I think the most frustrating thing about the wolf case for the people in Wyoming was the fact that that case got litigated in Washington, D.C. rather than in Wyoming, with a Wyoming federal district judge who knew the people, who knew the land, who knew the state. In fact, there was litigation in both Wyoming and Washington, D.C., and the case got moved over to Washington, D.C. to a judge who I don't think has any idea where Wyoming is, which one of the square states we are. That was one of the first problems. I think the second problem is that after the wolf case got sent back to Wyoming because they didn't have a commitment, a written commitment from the governor, the legislature and the Game and Fish immediately acted to put in that true written commitment on wolf recovery in place, but the case was over, the court wouldn't recognize it, and then the U.S. Fish and Wildlife Service refused to recognize it. So Wyoming tried to fix the problem identified by the court, and it didn't help.
My time has almost expired, so I will yield to the ranking member, Ms. Lawrence, for 4 minutes.
I appreciate my chairman's lesson on antelope and elk. I had no idea, so I learned something today. Mr. Glitzman, let's discuss the consequences that budget cuts have had. Would you agree, let's talk about this. Do you agree that that a lot of the litigation is due to an agency's missed deadlines?
Yes.
So the Fish Wildlife Services use innovative programs, but they're understaffed and underfunded, and they struggle to manage it. It's not surprising when funding cuts are made, and you have issue with missing deadlines, and plaintiffs sue the agency. What do you recommend, or what would you say to Congress as we talk about this, as we talk about the need to ensure that our sincere efforts to protect the endangered species, that one hand, because they're cutting the costs and staffing of that agency, and litigation is increasing, and I agree with the comment that was made, we need more scientists and less litigation. But can you comment on that and enlighten us?
I would say that, to me, it seems counterintuitive to address a research shortage by cutting funds still further. If the agency lacks sufficient funds to comply with the statutory responsibilities, the solution, it appears to me, would be to provide more funding and more staff. In recent years, the agency has experienced about a 10% decline in the levels of staffing, which obviously would make it more difficult for it to comply with its obligation to respond to petitions of all sorts on a timely basis. It would also, I think, increase the likelihood that when the agency does make a decision, it's not going to be as thorough, well-considered, or take into account all perspectives that ought to be taken into account. And it may be that the lack of funding is responsible for failure to consult more rigorously with all affected interests. They just don't have the time, the personnel, or the money to do so.
I thank you. Madam Chair, I just wanted to close with, when we have an objective in a bipartisan act, and we want to be able to use the full entirety of it, that we must look at the staffing that we have. And lack of funding leads to lawsuits. It also makes it difficult to keep species off the endangered species list, and it hampers the ability of the Fish and Wildlife to adequately oversee the recovery, which is ultimately the real barrier to delisting. And I yield back.
I thank the ranking member for her time and her participation in this hearing. The chair now recognizes the gentleman from Arkansas, Mr. Palmer, for 4 minutes.
Madam Chairman, if I may, I'd like to correct the record that I'm from Alabama.
Excuse me.
That's all right. Bruce Westerman would have been proud of it. Mr. Thornton, you were counsel to the House Fisheries and Wildlife Conservation Subcommittee during the congressional consideration of the 78 and 79 Endangered Species Act. As such, you have familiarity with the background and legislative intent of these amendments and their provisions. What is your understanding of the reason for that part of the law that creates the distinct population segments, or DPS?
So, Congressman, some of the problems you might be able to blame on me, perhaps, but
we're not blaming anyone.
It's very interesting because the distinct population segment question was controversial at the time, and I think there was a recognition that there was a potential for abuse of listing of distinct populations and the inability to properly define what is a distinct population. Just, if you bear with me, a little story. In the course of the testimony during the oversight hearings in 1979, the Fish and Wildlife Service was responding to the complaints about the ability to list distinct population segments, and they cited as an example of why they needed population authority was their downlisting of the American alligator in the southern parishes of Louisiana. That was near and dear to the then chair of the subcommittee, Congressman John Breaux, who represented Southwest Louisiana and had worked for a number of years to have the state implement a management program that was phenomenally successful in increasing the populations of alligators and then subsequently reducing the regulations. And frankly, it was the case that they made to Congressman Breaux that we need this authority to give us more flexibility in the statute to remove those populations from the list when they recover, when they're not threatened. That hasn't been the
case, has it?
No, in fact, unfortunately, it's worked just the opposite, where the DPS authority is now used as a barrier.
You mentioned the possibility of it being abused. Do you believe it's been abused?
I do think that, in general, the barriers that have been created by a listing of distinct population segments, which has increased, and now in some of the litigation that's occurred, the inability to delist component parts of a broader listed species, a subspecies, or a species, where it's recognized that there are individual populations that are recovered, the courts have made it more difficult to delist those individual segments.
Okay. Mr. Bayer, you had a slide up during your opening remarks. Could you please explain the second graphic exhibit in your written statement regarding the delisting attempts for the wolves and grizzly bears, all of which it seems the courts have overturned and reversed?
Yes, thank you, Mr. Palmer. If you all will get that graphic in front of you, if we can put it up, the vagueness of the language in ESA surrounding distinct population segments, a significant portion of a species range, or the adequacy of existing regulatory mechanisms to manage a species once recovered, are the three areas, the three sets of language in the Act which has led to the inability to delist the wolf, both in the Great Lakes and northern Rocky Mountains, and pretends to do so with the Yellowstone grizzly. What this graph does is serially by year walk down through for each of the species the delisting or downlisting of the species by the service, and then under each of those shows the delisting being reversed by a court. And at the bottom, you'll see key to the grounds for reversal. There's 3 different grounds down there, 1, 2, and 3. And so in this graph, you'll see in parens under each reversal, either a 1, a 2, or a 3. And those show the specific language upon which the court's decision turned to delisting. I wish we would have put these court decisions in red, but that's what this graph shows, is that because of the vagueness of the language itself, each of these cases has turned on one of 3.
I'd just like to point out that in regard to the distinct population segments, it was used 7 times. I yield back.
I thank the gentleman and recognize the arrival of our vice chair, the gentleman from Colorado, Mr. Buck, who will be recognized for 5 minutes due to the fact that he missed the first round. Mr. Buck, you are recognized for 5 minutes.
Thank you, Madam Chair. Ms. Bud Fallon, I had the pleasure of practicing law in Cheyenne for a short period of time, and I remember a saying, actually probably more outside the bar than inside the bar, but if there's one lawyer in town, the lawyer starves. If there are 2 lawyers in town, both lawyers become very wealthy. I'm trying to figure out the attorney's fees with the Endangered Species Act and what the legal basis for those attorney's fees are.
The Endangered Species Act is actually paid out under a provision in the ESA itself, which means that the fees for that act are paid from the Judgment Fund, not from the Equal Access to Justice Act. The Judgment Fund allows payment for achieving part of the goal of the litigation, whatever part of that goal might be. So even if the goal is simply Fish and Wildlife Service, you missed a time deadline, that is achieving the goal of the litigation, you get paid your attorney's fees. There is no cap on the hourly fee that you charge under the Judgment Fund, so $500 an hour or $7 or whatever. They don't pay Cheyenne attorneys that, but whatever the attorney's fees paid are, that gets paid. I pulled the Department of Justice run sheets from 2010 to 2015 just for Endangered Species Act cases alone, and found that over $9 million was paid in attorney's fees from 2010 to 2015 for ESA cases solely.
And so how much did the Department of Justice recover from plaintiffs' attorneys that filed frivolous lawsuits?
None. There is no fee shifting in the opposite direction. So if I lose a case against the Justice Department, I don't have to pay.
One of the beauties of Wyoming is this common sense. Does that encourage or discourage people from filing lawsuits when they get money, if any small part of their suit is successful, but they don't have to risk anything if they are deemed to have filed a frivolous lawsuit?
Quite honestly, Mr. Buck, I think that there is no downside to filing this kind of litigation. I have seen these attorney's fees cases and these ESA cases brought by students of Denver University Law School. We've seen these brought by, quote, nonprofit organizations. The attorney's fees go strictly back into them. The vast majority of attorney's fees we found is done through a settlement agreement. So we have no idea, as the American public, the hours charged for a particular task in the litigation or the hourly fee charged by the attorney.
And what is the effect on the administration of the Endangered Species Act or the administration generally in government when individuals file lawsuits? Does it prolong the study or effort to move forward on certain issues?
Yesterday at the hearing, Director Ash talked about how litigation wasn't even a consideration. He is not getting that from his staff. The staff people on the ground will absolutely tell you that they spend so much time preparing for litigation, responding to Freedom of Information Act requests, that they simply cannot do their job because all of their hours are sucked up in litigation. So it may not be a policy at the top, but it is killing the regular Fish and Wildlife Service or Bureau of Land Management or Forest Service people at the bottom of the totem pole.
And the effect is really twofold. On the one hand, where a species should be delisted, it would take much longer, and where a species may need to be listed, at the same time, those individuals that are burdened with paperwork don't have the ability to go out and do their job.
That's correct. They don't have time to go do the science and gather up the information so that they can figure out if something needs to get off the list, or so that they can set a recovery bar so that states and landowners can work toward a goal to get it off the list.
And I appreciate your testimony. I yield back.
Now I wish to ask each member of our panel to use 1 minute each to say anything that they wish they could have said but was not asked of them. Mr. Baer, thank you for your testimony. You are recognized for 1 minute if you wish to use it.
Thank you, Madam Chairman. I wish Mr. Zinke were still here. I checked my record. He asked me how much, Mr. Buck, how much was spent on payments each year. What is these lawsuits costing us as taxpayers? And I said it was over $1 million. I was having trouble remembering. It's about $49 million. For fiscal years 9 and 10, we went back and checked the records, and the average is about $49 million for those 2 years. We need to have an open book. I've had to do the research. Karen Budd-Fallon's had to go back and do the individual research to find out how much is being paid out. And thank God, in the energy bill, the Equal Access to Justice Act reform measure that Chairman Lummis has been a champion on in the House has finally passed. And now it's in the energy bill, which I understand was finally passed. So we're going to get an open book finally, so we can keep track of this. Thank you, Madam Chair.
Thank the gentleman.
And thank you for your championing this for 6 years. It's taken 6 years to get that open book finally passed.
I commend also to those in attendance Mr. Baer's book, which is sitting on the dais or on the table next to him. It's exhaustive research and factual information on the Equal Access to Justice Act. Mr. Thornton, you are recognized for 1 minute.
Madam Chair, I think what I would like to add, that I think it's very important that Congress focus on the issue of what constitutes best science. That was added to the statute when I was counsel of the committee in 1978. The thought was that it established a higher standard for the Fish and Wildlife Service to meet. Frankly, that has not worked out in practice. And we get into the problem of the agency relying on the defense, well, these are technical issues, and therefore you have to defer to the agency. I think there have to be some standard of what constitutes best science. One element that I spoke about in my testimony is transparency. It seems to me that should be non-controversial, that there should not be hiding the data, that you shouldn't have to file lawsuits, as I've had to do, just in order to obtain the data, which we had to do in the Gnatcatcher. You shouldn't have to have the agency hiding behind the so-called deliberative process exemption in the Freedom of Information Act and refuse to provide information that is, after all, facts that's in possession of the agency or in possession of the agency's consultants, and that an understanding that best science means that the agencies are obliged to use what is the current standard in the profession and, frankly, not rely simply on what might have been perfectly adequate science in 1920, but is no longer.
I thank the gentleman for his specific recommendations about how to improve the implementation of the Act. Mr. Bousman, you are recognized for 1 minute.
Thank you, Madam Chairman. The one thing that comes to my mind, to give an example, an on-the-ground example of how local government participating with a federal agency can actually improve the outcome of a process and decrease the prospects of litigation. The Forest Service, 3 or 4 years ago, started an analysis in the Hams Fork area in northern Lincoln County. They wanted to do a timber management project, and up until that time, every time the Forest Service seemed to propose cutting trees that might create jobs and thin the forest and reduce the cost of fire suppression, it got litigated. In this case, with the help from the county's involvement and the governor's office involvement, working with the Forest Service in a collaborative effort, bringing in representatives from local environmental groups whose national group tends to litigate, by involving that local component in a collaborative effort up front in developing this forest management plan, that record of decision on the Hams Fork was not litigated at all. The record of decision stood as it was proposed, and now we're in the process of actually putting out, letting people bid on projects to harvest trees, make the forest a healthier forest for all the multiple uses that use that forest. And it's a win-win for everybody. But it required the in-depth participation at the local level to make that happen.
I thank the gentleman and commend you on your leadership on these issues. Mr. Glicksman.
Yes.
You are recognized for 1 minute.
Thank you. I'd like to point out first that there are costs to the filing of frivolous lawsuits under the ESA and elsewhere. There's a reputational cost to an attorney in a case in which a judge says that the suit was frivolous. There are sanctions available under the Federal Rules of Civil Procedure for bringing frivolous lawsuits, although they're not often exercised. And attorney's fees are not going to be reimbursed if the plaintiff loses. But I wanted to end by pointing out that I think there's common ground between me and at least some of the points of each of my co-panelists. So I would agree, for example, that the ultimate goal of the statute ought to be protection of ecosystems, not protection of individual species alone. I wouldn't necessarily agree that we need fewer lawyers. As a law professor, that would be against my self-interest, but I do agree that we need more scientists, especially at the Fish and Wildlife Service. I agree that recovery plans should have clear metrics that indicate when we have met recovery goals. I agree that policy-based decisions in natural resources management are often best when they're a result of collaboration among and decisions that are acceptable by all levels of government. So I do encourage collaboration between the Fish and Wildlife Service and lower levels of government. And finally, I think that one advantage of authorizing federal action is its capacity to act as a resource pooler. And so the idea of the Fish and Wildlife Service providing needed information to allow local governments to act in ways that are beneficial to species while protecting economic interest is an attractive one to me. Thank you.
Well, I thank you, Mr. Glicksman, and we are seeking common ground, and I believe we found some today. Thank you for your testimony. Ms. Bud Fallon, you are recognized for 1 minute.
Thank you, Congresswoman. I think that I would agree with my panelists that one of the biggest problems we have now is that often we don't have goals for how many species we need or what kind of habitat we need. Species get put on the list without clear goals, without clear recovery, and then states and private landowners simply can't manage to what they don't know to manage for. I think that if the Fish and Wildlife Service truly wants to recover species, they need to tell us what they want. Or let the states and local governments figure out what they want so that they can manage for. It's impossible to manage for something if you don't have a goal. I do think, though, that it's a little sort of disingenuous to say, oh, states can just keep species off the list if they just manage better for the species. The problem is you've got all the litigation. And so even if a species, for example, in the lesser prairie chicken case, is putting together a range-wide plan covering 5 different states and 5.8 million acres, Center for Biological Diversity sued anyway. And the court, or the Fish and Wildlife Service, said the range-wide plan doesn't have a chance to work. We're not going to wait for all the CCAAs in place. We're listing it anyway. And then we just went through 2 years of litigation where the court finally said, Fish and Wildlife Service, you didn't give the range-wide plan a chance to work, and so the listing got vacated. Fish and Wildlife Service has to determine if they're going to appeal that to the Fifth Circuit Court of Appeals. I think their timeline's like another 10 days to appeal it or not. So that was a case where you had 5 states trying to do the right thing, and it got preempted by litigation. The species ought to matter, not the litigation, and I'm afraid that's the way it works now. Thank you.
Well, this panel has exhibited great expertise and an effort to find common ground to recover species. And that's what we're after, and we are deeply grateful to each one of you who has traveled far to offer up and share your expertise. I'm hopeful that your wise admonitions and advice will change the way the Endangered Species Act is used in the future, so species recovery is paramount to other considerations, as I believe the people who envisioned the Endangered Species Act in 1973 envisioned. So with that, I would like to thank our witnesses for taking the time to appear before us today. And if there is no further business, without objection, the subcommittee stands adjourned.